Welcome to the Deep Dive. Today, we're pulling back the curtain on three major legal battles.
Yeah.
Now, at first glance, they might seem completely unrelated. One's about, your online world, another about citizenship itself, and a third touches healthcare access. But as we dig in, you'll start to see these surprising threads connecting them all. It's really about how our highest court is, well, actively redrawing the lines of individual rights and government power in 21st century America, often in ways you might not even realize. It's a story about who we are, what we can do, and what we're entitled to. And it's all unfolding right now.
And these aren't just, abstract legal ideas for the textbooks. These are incredibly current live issues. They have real-world consequences that, frankly, touch your life directly. Everything from how you get information online to your healthcare, maybe even how citizenship is defined for some. And it's particularly relevant today, June 27th, 2025. Because, well, the Supreme Court actually released its decision on Free Speech Coalition, Inc. v. Paxton, just hours ago. And they also issued a ruling related to nationwide injunctions that impacts the birthright citizenship case we're going to talk about. So yeah, it makes this deep dive incredibly timely.
Definitely. So join us as we unpack this, constantly shifting legal landscape. Okay, let's jump right in. The digital frontier of free speech. As you just mentioned, the Supreme Court handed down a pretty significant decision today, June 27th, in Free Speech Coalition, Inc. v. Paxton. This case is all about HB 1181. It's a Texas law aimed at regulating online sexual material.
Right. Essentially, HB 1181 targets commercial websites, specifically sites where more than one-third of their content fits a very specific legal definition. The definition is sexual material harmful to minors. So we're talking about material designed to appeal to the prurient interests of minors, depicting certain sex acts or anatomy in a way that's patently offensive for kids, and critically, lacking serious literary, artistic, political, or scientific value for minors. It's, a precise legal standard.
Okay, and here's where the legal reasoning gets really interesting, I think. The Supreme Court actually upheld this Texas law, which might surprise some people, right?
Yeah.
Especially given past rulings. They applied what's called intermediate scrutiny. They reasoned that the law only incidentally burdens the protected speech of adults.
Can you walk us through what that means? Why that specific level of scrutiny, and what does it tell us about the court's current thinking here? Yeah, that's a key distinction. You see, in earlier cases, think Reno or Ashcroft II, similar laws about online content got hit with strict scrutiny. That's because those laws were seen as basically outright bans, or they effectively suppress speech for adults. But in Paxton, the court saw HB 1181 differently. They framed it as an age verification requirement, not a ban. And that shift in perspective, it changed the legal test. They moved down to intermediate scrutiny, which is, it's a less demanding standard for the government to meet.
Okay, so if the court sees this as just age verification, what does that actually look like for a website? Are we talking about something completely new and complicated? There are methods that are already out there. And is it really less burdensome than a ban, like the court suggests?
Good question. So the law allows age verification using things like government-issued ID or transactional data. These aren't entirely new ideas. They're actually pretty common in other sectors. Think online gambling, alcohol, tobacco sales, even car rentals. And maybe, ironically, parts of the online adult content industry itself have used similar age gate methods for, decades. So it's not some brand new, untested tech.
Still, Justice Kagan, in her dissent, she had some pretty pointed criticism, called the majority's reasoning circular even. What was her main critique? Why was she so concerned about using intermediate scrutiny here?
Right. Her dissent basically argued strict scrutiny should have applied. Because the law clearly draws lines based on content, right? And it fundamentally gets in the way of adults accessing speech. She highlighted what she saw as the majority's circular logic, essentially saying the court argued, requiring age verification doesn't directly burden adult speech because adults don't have a right to be free from the burden of age verification. Her big worry was that intermediate scrutiny lets Texas off the hook. They don't have to find the least speech-restrictive way to do this. And it potentially ignores how burdensome the law might actually be. Does it hit all content? Does it apply to all minors? Does it even allow for newer, maybe less privacy-invasive methods like biometrics down the line? It's a strong challenge to the majority's view.
And this decision doesn't exist in a vacuum, right? It lands right in the middle of this really fragmented landscape. State-specific online child safety rules are popping up everywhere. We're seeing a real patchwork developing. States like Arkansas, Louisiana, California, Utah, they all have their own versions.
Exactly. So for you, the listener, what does this actually mean for your privacy? How you access content online? It also kind of broadens the conversation to bigger questions. Things like digital literacy, parental responsibility. That's a huge part of the public discussion around these laws. You see a lot online about, well, maybe parents needing to be more involved in supervising what kids do online as the law tries to catch up.
Okay, so we've just seen how the court is grappling with free speech in our, well, very digital lives. But while tech throws up new challenges, some legal questions are, frankly, as old as the nation itself. Yet they still ignite really passionate debate. Let's turn now to one of the most fundamental, birthright citizenship. The principle of just, basically, if you're born here, you're a U.S. citizen, regardless of your parents' status. It feels like bedrock to a lot of people, but it's become a real flashpoint again in the national debate, constantly being challenged, maybe redefined.
Yeah, and this idea that your status is vested at birth and based upon place of birth, it has really deep roots. It traces all the way back to English common law. You can look at Calvin's case in 1608, so a very old legal concept.
But here's where that history takes a really crucial and, well, frankly, dark turn. Think about Dred Scott v. Sandford, 1857. The Supreme Court ruled, shockingly, that African Americans, slave or free, could never be U.S. citizens. And it's really important to stress this decision was based on what legal scholars pretty much universally call a deeply skewed reading of history.
And what's fascinating is how the Civil Rights Act of 1866 directly pushed back against that. It declared, quote, all persons born in the United States and not subject to any foreign power excluding Indians not taxed are hereby declared to be citizens. The clear intention was to state what the law is or should be, correcting that historical wrong. But even that wasn't the end of the story. Think about Elk v. Wilkins in 1884. The court denied birthright citizenship to Native Americans. They argued Native Americans weren't subject to the jurisdiction of the U.S. in the same way. It's a complex history. We could also briefly mention the Cable Act of 1922 that significantly impacted women's citizenship, untangling it from their husband's status.
Right, so bringing us to today, there have been proposals, constitutional amendments to change birthright citizenship, floated quite a bit, actually, though none have ever cleared the high bar needed for ratification by the states.
And if just solis were eliminated, the potential impact is, well, staggering. There was a report back in 2010 estimating that by 2050, something like 4.7 million American-born people could end up being non-citizens if birthright citizenship was ended for children of non-citizens. That's a huge demographic and legal shift to even contemplate.
And we've seen some really significant recent moves on this. The former president signed an executive order January 20th, 2025, attempting to end birthright citizenship for children of, quote, illegal migrants. That sounds like a pretty direct challenge to the established understanding, doesn't it?
Absolutely. And it really highlights how hard it is to just overturn something so embedded in constitutional interpretation without a much bigger legal change. Predictably, immediate legal challenges popped up. The ACLU sued, 22 states sued, and federal judges have since blocked that order, which, often happens when executive actions push the boundaries of existing law like that.
Right. It's not like flipping a switch. And then today's Supreme Court ruling on nationwide injunctions, that kind of further complicates the birthright citizenship case, doesn't it? Leaves its fate a bit up in the air.
Precisely. Yeah, to bring us right up to this minute. The Supreme Court had already agreed back on April 17th, 2025, to hear arguments in the main birthright citizenship case. But yes, today, June 27th, the court issued this separate ruling on nationwide injunctions, and that does directly impact how this case might proceed. It leaves the ultimate fate unresolved for now, adds another layer of uncertainty, almost like a holding pattern, while the bigger legal arguments play out. It just reminds you these big cases rarely have simple, quick endings.
So what does this ongoing legal fight mean for real people, for you, for families out there? Are there tangible, everyday impacts being felt right now from this uncertainty?
Oh, absolutely. There are tangible impacts. Studies point to pretty significant health and social costs tied to challenging birthright citizenship. For example, you see reports of mixed status families maybe avoiding public programs because of green card concerns, or parents pulling kids from childcare out of fear about immigration status questions. Basically fear that interacting with any public system could lead to trouble. And we're also seeing new state laws emerge, like Texas hospitals asking about patient immigration status. That shows how these high-level debates ripple down into daily life.
Okay, let's connect this back to the deeper constitutional arguments for a second. What's the originalist take on the 14th Amendment Citizenship Clause? How do they interpret subject to the jurisdiction?
Right, so if you look at it from an originalist perspective, the thinking is generally that the phrase born in the United States likely meant born in territory under permanent U.S. sovereignty. Pretty straightforward. And subject to the jurisdiction typically meant physically within U.S. territory, but with specific understood exceptions like foreign diplomats or members of Native American tribes who had their own sovereign relationships. Crucially, though, historical evidence suggests the drafters of the 14th Amendment themselves generally did understand that the clause would include U.S.-born children of aliens residing here. So the historical intent seems pretty clear on that point, actually.
Okay, let's shift gears one more time. Now to healthcare in this sort of balance of power question. We're talking about the crucial Braidwood v. Becerra case. The Supreme Court is set to hear oral arguments on this one back on April 21st, 2025. And this case challenges a core piece of how preventative care coverage is mandated under the Affordable Care Act, the ACA.
Yeah, the absolute heart of the legal challenge in Braidwood is about the U.S. Preventive Services Task Force, the USPSTF. Specifically, whether its members are constitutionally considered principal officers or inferior officers. Now, this might sound like dry legal jargon, right? But it's fundamental to checks and balances. Basically, principal officers usually have broad, independent power and need Senate confirmation. Think cabinet secretaries. Inferior officers have more limited authority, and they report to and can be removed by a higher up, like a secretary, creating accountability to the president. The argument, stemming from the Trump administration initially, was that these USPSTF members were acting like principal officers, making really significant policy decisions about what care must be covered, but without that proper appointment process or direct accountability. They argued they should be seen as inferior, meaning their recommendations could be more easily overseen or even overruled by political appointees in HHS.
Okay, and this is where the potential impact really comes into focus. Because if the courts agree with that argument, if they say, yes, these USPSTF members are acting like principal officers without proper appointment, and so the delegation of authority is unconstitutional, well, that could lead to some pretty big, maybe unforeseen consequences. What exactly are we talking about in terms of real-world impact on healthcare coverage?
Well, yeah, if that ruling happens, it could mean health plans might no longer be required to cover preventive services that were recommended by the USPSTF after March 10th, 2010. And just to give you some concrete examples of the kinds of services we're talking about, these are really common, important things like colon cancer screening, preconception and prenatal care during well woman visits, certain tests and meds for breast cancer risk reduction, like BRCA screening, also tobacco cessation counseling, vision and hearing screenings for kids, and notably all FDA-approved contraceptive methods, sterilization procedures, and related patient education. It's a wide range. Now, it is important to note, recommendations made before March 10th, 2010 that Congress itself adopted, those aren't subject to this particular challenge.
And you see groups like Medicare Rights having a really strong interest in this case, which makes sense, right? Medicare is eventually the insurer for the vast majority of Americans, so they have a vested interest in making sure people get preventative care before they end up on Medicare. It's about managing long-term health and costs.
Exactly. And this case also taps into these broader debates we see around healthcare decisions and authority. You sometimes see discussions online, for example, raising concerns about whether certain legislative acts might allow insurance companies to deny reimbursement for care based on, say, religious morals. Things like contraception or abortion care under what critics call ill-defined limits. It just highlights that ongoing tension in our healthcare system over who decides what's covered and why.
So, for you, the listener, it's worth thinking about. How might a ruling in Braidwood directly impact your own healthcare access or the broader landscape of public health policy in the U.S.? It's definitely a case to keep an eye on. So we've journeyed through some major legal battlegrounds today, from, digital rights online to the fundamental definition of citizenship and the details of healthcare coverage. What's the connecting thread for you here? What ties these seemingly disparate issues together?
Well, what these cases really show, I think, is how our foundational legal principles, many crafted centuries ago, like the First and 14th Amendments, are being seriously stress tested. They're being tested by rapid technological change, by shifting societal values and norms. It's more than just tension. It's this constant dynamic push and pull. And it fundamentally redefines what it means to be free, what it means to be secure, what it means to be healthy in modern America.
Yeah.
It's forcing the courts, especially the Supreme Court, to essentially redraw lines we might have once thought were pretty permanent.
Yeah, this deep dive really underscores how profoundly these legal decisions weave through our daily lives. often in ways you might not even consider at first glance. They aren't just abstract rulings happening somewhere else. They are, in a way, the invisible architecture shaping our society, shaping your experiences.
Right. So the question that leaves us with perhaps is, what responsibility do we have as informed citizens? Not just to passively observe, but to really understand and maybe even engage with these complex legal processes that are continually redefining our freedoms in our society. What questions does this whole landscape raise for you personally about how power is balanced, how rights are protected in a world that's constantly changing, and maybe what role you might play in shaping those future definitions?